So what exactly is Florida probate? It's a great question, and I'm going to answer it for you in this Women Empowered Minute. Hi, I'm Kristen Marks, founder of My Pink Lawyer, women lawyers committed to saving your loved ones time, money, government interference, and family disputes with practical, effective family succession planning. In my earlier videos, I shared with you why having a will, life insurance, retirement, and even a living trust may not help you avoid probate when you die. But you might be thinking to yourself, what the heck is probate anyway, and why would I want to avoid it? There are several different types of Florida probates, but the type most people think of when they hear the word probate is what's called a formal administration. With a Florida formal administration, the probate court appoints a personal representative to administer a decedent's estate. Some states call this person an executor or executrix. In Florida, we use the gender-neutral term personal representative. The personal representative is responsible for gathering together all of the decedent's estate assets, figuring out who the decedent's creditors are and notifying them, paying the decedent's final bills and administration expenses from the decedent's assets, and finally, at the end of the probate process, distributing the decedent's assets to whomever is supposed to inherit them. Remember that if a decedent died with a will, what we call a testate estate, then the beneficiaries named therein will inherit. If a decedent died without a will, what we call an intestate estate, then the decedent's legal heirs under Florida law will inherit. Although Florida probates do serve the function of retitling a decedent's assets after they die, formal administrations in particular are often time-consuming and expensive. Florida formal administrations follow a certain sequence of events that must be followed in order. Plus, there are mandatory waiting periods built into the process as well. Florida formal administrations that are uncontested and fall below the federal estate tax threshold typically take anywhere from between 7 and 12 months to administer. If there is fighting over the estate or unique assets that we are trying to sell, or estate tax returns that need to be filed, the probate process can take significantly longer than that. Florida formal administration fees are typically significantly more expensive than structuring your estate plan in the first place so as to avoid probate. And sorry, there's no getting around it. A personal representative in Florida must be represented by an attorney. Some probate attorneys charge a percentage of the estate assets. Others charge by the hour, which can become very costly very quickly. At My Pink Lawyer, we charge flat probate fees for all uncontested probates, so there are no surprise bills. If you are looking to handle a Florida probate for a loved one who has died, make sure that you are working with a Florida licensed attorney who specializes in that type of work. If you are looking to set up your own estate plan to avoid probate, or as we like to call them in our office, a family succession plan, make sure you work with a Florida licensed attorney who specializes in that type of work. At My Pink Lawyer, the only types of matters that we currently handle are uncontested wills, trusts, and estates, and certain type of guardianship matters. To learn more about avoiding probate, download our free book on avoiding the most common estate planning mistakes at mypinklawyer.com or at pinklawyerbook.com.